Federal defense attorney Ronald W. Chapman II and distinguished professor at Touro University, Thane Rosenbaum. Gentlemen, good morning. Thanks for being with us today.
Good morning.
Good morning.
All right, Ronald, I'll start with you. This is now Trump's third criminal case. What do you make of the severity of this case compared to the others? Do you think this one holds more weight or less in comparison?
Well, this one is going to be a much tougher sell for Jack Smith. We have here essentially charges that are limited in nature. If you look at the indictment, you'll notice that he didn't charge the rhetoric and the statements causing January 6th, but what he did charge is this sort of fake electors scheme that they're looking at in Georgia as well. That's going to be much tougher to get a conviction on. The reality is that all of the attorneys who may be witnesses in the case, including Sidney Powell, Rudy Giuliani, likely will take the stand and have to testify, but the cross-examination of those witnesses will hinge heavily on their prior statements in the media, reflecting exactly what Donald Trump also knew. This sets up a potential advice of counsel defense, where Trump can argue that he was essentially advised by his attorneys that there was election interference and had a reasonable belief to that effect. This is not as good as the classified records case, and it's going to be a difficult trial for the government.
Speaking of his attorneys, Alina Harbour expressed her opinions on the case on Thursday. Let's take a quick listen to those.
What is it that he did to try and switch the votes that you refer to? By bringing cases, by using the law in an appropriate manner, unlike what we're sitting here today seeing? This is not appropriate. What President Trump did is he said, go patriotically and peacefully and protest. That is an American right. That is why we are America and we are not a third world country. Although I will say that today, I don't feel very much like we are in America.
Thane, I want to get your reaction to that, to what Alina just said there.
What's interesting is she used the let us all march peacefully and patriotically over to the Capitol building and make our voices heard. And the reason that's interesting is because the incitement to a riot is not a charged crime in this indictment. Similarly, the image that you're using now, the press conference of Jack Smith, it's very much a bait and switch. You know what he's saying right there? He's reminding everybody about the violence of the rioting and seizing of the Capitol building. But then how come it's not in? Why is that? First of all, the language itself that Lena just mentioned, peacefully and patriotically, which is an exonerating line. That is, anyone who says peacefully and patriotically marching over to make our voices heard is not inciting a riot. But the government and major media has consistently ignored that. So I'm glad that you played that particular phrase. Yeah. And again, it seems like a bait and switch. It's bad faith. Jack Smith is using creative readings of criminal law that never really apply in this situation. The Congress focused entirely on the incitement of the riot, and that is not a charged crime here at all. So I do agree that this is a weaker case. It's a case that is fundamentally about political speech. Political speech under the First Amendment is supposed to be granted the highest level of protection of speech. And even the conduct that the president was involved in involves speech. So this is really about the First Amendment.
Yeah, I like the way you phrased it there, Thane, with the bait and switch. I think it's a misapplication of law, among many other things. But what else are they going to do, right? They're just bootstrapping whatever they can to make it look like it's really bad. You know, Orange Man bad. But the New York Times saying the proceedings against Mr. Trump streamlines the case and gives Mr. Smith the best chance for a trial to be held and concluded before the 2024 presidential election. So, Ronald, when you see things like this and the trial taking place before the election, it seems to me that's the only thing they care about, is making sure they can disrupt his campaign and get this done before the election. The substance completely irrelevant, or at least that's how I read it. What say you?
Well, that's it. I mean, getting an investigation like this off the ground in such a quick time period shows that the government is motivated solely by getting this case done before the election. Now, that's not going to happen. As much as the judge tries to push this case forward, I think there's absolutely no chance, given the volume of discovery that will have to be reviewed here. Remember, and Trump's team has been saying, we just got this case. We're just getting discovery now. They've had years to look into this information, and we need a similar amount of time. That is a very legitimate claim for a defense counsel. And let's go back to the nature of the charges. It's not rhetoric, it's not speech that really should be charged here. What Jack Smith is charging is the fake elector scheme. This is something that we saw happen in Hawaii in Kennedy versus Nixon many, many years ago. It's just strange that he's looking at these federal statutes to try to charge this sort of fake electors conduct. This is a confusing trial. It's going to be very difficult, and it's not going to get off the ground before the election.
All right. Thank you very much for joining us, Ronald W. Chapman II and Thane Rosenbaum. We really appreciate your input on this topic.
Thank you.
All right.
Thank
We've
you.
got